hearing session is now open. Please could you ensure that all electronic devices are set to silent and that your cameras are switched off unless you're being addressed by one of us or have been invited to speak. As you know from the previous sessions, my name is Carol Dillon and I'm joined by fellow inspectors Louise Crosby, who you met last July, and also Nick Palmer, and he's examining the minerals and waste aspects of the Shropshire local plan. Kerry Truman, the programme officer for the examination, continues to deal with the administrative matters and is on hand throughout this session. Now, this particular event is a continuation of stage 1 hearing sessions for the examination of the Shropshire local plan. And for everybody's benefit, we'll be referring to that document as the plan for the purposes of this session. Now, the focus of today is purely about whether or not the council has met its duty, and in particular bearing in mind the additional duty to cooperate material that was submitted by the council after the close of the hearing sessions that were held last summer. We're aware that the Association of the Black Country Authorities are no longer working towards a joint plan, and instead they're preparing separate plans. Now, I just want to make you all aware that this change doesn't affect the legal duty. This is because the test we must apply relates to whether the duty had been met at the time the plan was submitted. That matter cannot be remedied after submission. This is unlike the soundness matters in relation to the duty, which can be rectified during the examination in theory. And they include the cross-cutting issues that we discussed during the other stage 1 sessions, and they may also crop up at subsequent hearing sessions should we find the legal duty has been met. Now, ahead of our discussion, I need to run through a few housekeeping matters relating to today's event, so we're all certain on how things are going to be run today. Now, I do appreciate that at least some of you have had experience in virtual sessions that we held last summer, but if you could just still pay attention, just in case there are any slight changes. Now, if you lose connectivity, please rejoin using the link which you originally got for this event. And if you encounter any difficulties in doing that, try the good old trusty restart of your device first of all. That does often cure the problem. Now, Kerry will be available to speak by phone or email if your problem does persist. And just bear in mind that the session is being recorded and live streamed, so unless this all happens during your turn to speak, we're likely to continue on as you would be able to catch up on what had been what. Now, we won't be using the chat function today, and it has been disabled, but just so you're aware of that. And we'll be following the agenda which was circulated to you all last week by the programme officer, and I trust that you have a copy of that. Mrs. Crosby will be leading what should be a relatively relaxed and informal discussion focusing on the duty to cooperate. She may have some questions for you, and if either myself or Mr. Palmer have any questions as the session progresses, we'll switch our cameras on at the relevant point, and that will alert Mrs. Crosby that we'd like to pose some questions. We'll start by allowing the council to highlight the most pertinent points contained within their response to our matters, issues and questions that were contained in ID 24. So that's our latest matters, issues and questions document. Once they've done this, we'll invite you to raise your virtual hand if you wish to speak. And then we'll invite you each in turn to speak, and that will be in the order that Teams puts you in our participants list. Now, when it's indicated that it's your turn, please ensure that your camera and microphone are switched on, and you may draw our attention to any pertinent points of your own statement and in relation to the council's stance. However, when speaking, just be mindful to be concise and make sure that you don't deviate from whether the council has met its duty into the matters of soundness, and that's quite easily done. And we will sort of remind you if that does happen. Now, there'll be no cross-examination of any participants. However, the council will be given the opportunity to respond to what has been said, so having the last say essentially, and answer any questions that we have before we move on to hearing from the next participant. We're not inviting evidence on emission sites, and we'd also ask you kindly to refrain from doing that, and we will remind you if you do stray into that. Should we find that the council needs to allocate more sites, then it would be for the council to identify these and test them. It's not a matter for today. We're not planning to accommodate your ability to respond back to a point unless we invite it to aid our understanding. And we don't anticipate that anyone will need a second opportunity to speak, as we do have the benefit of what we've heard at the last Duty to Cooperate session, and we're also in receipt of both sets of your hearing statements. Now, in terms of timings, we'll have a short comfort break around 11 o'clock and a lunch break around 12:30, and then we'll have a mid-afternoon break around 3 o'clock, because we are mindful that virtual sessions do place additional demands upon eyesight, etc., and concentration. So we can have a prompt start. I'd ask that you don't leave the Teams meeting during the breaks, but do remember to switch off your camera and your microphone so no one on the call hears or sees something that they shouldn't. Now, we will rejoin you all at the stated time. We don't envisage sitting beyond 5 o'clock today, and we'll take a view on whether tomorrow's reserve session is necessary later today, because that will depend on how much progress we make. If anyone is unhappy about today's session as it unfolds, please do let Mrs. Crosby or Kerry know straight away. And you could actually switch your camera on, just so that would alert us that there is something that needs to be drawn to our attention. And then so that we can seek to resolve the issues. Now, are there any questions on this format before we move on? If you do, if you could just switch your camera on. Okay, that doesn't appear to be any questions.
Ma'am, hello, it's Edward West from the planning, from the local planners team. It was just
Good morning.
Yes, hello. It was one question about the agenda today, specifically around the minerals and waste aspect. The reason why we mention this is because one officer who might be helpful in answering questions today has had a bit of an emergency today and may not be available later on this afternoon. But we also note that none of the participants that we're aware of have mentioned anything to do with minerals and waste. So those are questions 7, 8 and 9. So I was wondering whether you'd had a view on whether that matter could be dealt with earlier in the day. I'm in your hands on this one. I don't want to, obviously don't want to pressure you into anything at all, but I just wanted to highlight that as if that was a potential.
Okay. Louise, do you have or Nick, a view?
I'll let you go, Nick.
Oh, Nick.
I think you're on mute, Nick.
Sorry. Yes. Yes. I think that's reasonable to deal with it earlier in the day. I don't anticipate that I would have many questions on it. But yes, if we could find a slot fairly early on, that would be fine.
Thank you.
So in terms of dealing with it, it might be useful then if anybody can indicate in the hands up if they want to raise any points in relation to minerals and waste, any participants. I'm not aware that anybody has raised anything up to now. I think that the council just alluded to that as well. So can you just put your hand up if you particularly want to raise the minerals and waste point? No, not much interest there.
No.
So it's really if Mr. Palmer's got any questions, and I'm not aware that we particularly have anything.
Well, not particularly. No. I think the council has answered the questions that I set out in writing. Fundamentally, really, all of the questions have been answered, I think.
If you are happy to take our answers as read, we are happy for you to do that, obviously. So,
yes, Madam Sir, good morning. Hugh Richards, counsel for the council. In that case, we would propose to release the officer that Mr. West was talking about to go and do what he needs to do at a local hospital. We're confident, I think, that that will be satisfactory so far as we're concerned.
Yeah, and if there's anything pressing that arises throughout the day, it could be dealt with afterwards in writing or something. I don't think we should hold somebody up for the chance that it's a very slim chance that we would have a question, and it may be that somebody else could answer it anyway. I think, yeah, we should just let him go do what he needs to do.
Yes.
Thank you very much. Thank you very much.
Thank you. Are there any other questions? Okay, now I'll hand over to Mrs. Crosby. Thank you.
Thanks, Carol. So it might be useful, I think, first just to go around the virtual room, and if everybody can just introduce themselves. So if we start with the council and ABCA. So ABCA, as I understand it, are still in existence as a kind of organisation that comes together, even though the plans are being done individually by individual authorities. And we do have 3 people on the call today who are effectively sitting with the council. So they're dialing in from a different place, I think, to the council, but they are supporting the council this morning. So we've got Mr. Ball. Do you want to say anything, Mr. Ball, in opening, just to introduce yourself? Or?
Good morning, ma'am. Yeah, Neville Ball from Walsall Council. I think the examination will be aware that Walsall submitted a separate statement to a separate representation on the plan, but we have no specific issues with the duty to cooperate role. So we're really here to support Shropshire today.
Thank you, Mr. Ball. And then I think we've got Miss Popplewell from Dudley. Morning.
Good morning, ma'am. Vicky Popwell, Planning Policy Manager at Dudley Council. As supporting the Shropshire team today, as just to reinforce, as Neville Ball just said, we're here to support Shropshire, and we have an agreed statement of common ground with Shropshire Council.
Thank you, that's helpful. And then Mr. Cully, we've got from Wolverhampton Council as well. Morning.
Thank you. Morning, Ma'am. Yeah, echo what Neville and Vicky have just said, really. So we're here to support the council to explain basically what's happened following the cessation of work on Black Country Plan in October, and how the individual authorities have responded to that and bringing forward their own local development schemes. So happy to elaborate on that if that would assist in the examination. Our statement kind of sets out our position in relation to the specific questions, and again we're happy to elaborate on those during the hearing today. Thank you.
Thanks, Mr. Cully. So then we've got the council, who I think are all sat in the same room, as I understand it.
Yes, hello, Ma'am. Yes, we are all here in the same room together. So I'll introduce myself. So I'm Edward West. I'm the planning policy manager at Shropshire Council. I'll let Dan.
I'm Daniel Corden, one of the principal planning officers at Shropshire Council.
And Hugh Richards, counsel for the council.
Liam Cowden, Principal Policy Officer.
Tim Shrewsbury, Minerals and Waste and Policy.
Thank you. Hopefully we won't have the same problems we had in July with overheating, given it's about -4 here this morning. So.
Yeah, thank you for that. Yeah, yes, it is a different set of climate, should you say today in this room, but we have had conversations with the various parties, so we are hopeful that we don't get any interruptions about that today. Can I also just say that I think on the screen we are coming up as Wilfred Owen room still. I know that has caused some kind of issue. Unfortunately, we weren't able to rectify that because that would have meant a reboot of the system, which are, for reasons which I don't pretend to know, wasn't possible, unfortunately. So it's not Wilfred Owen, it's Shropshire Council. So apologies for that.
Thank you. Okay, so we've gone through everybody at the council now, so we'll move on to the participants. So I'll run through the list that I've got in order. So Ms Rawlins from Shifnal Town Council.
Good morning.
Morning, Ms Rawlins.
Good morning. I'm Claire Rawlings. I'm here on behalf of Bruton Knowles and, as you say, representing Shifnal Matters, Shifnal Town Council and Tong Parish Council. Good morning.
Thank you. And then we've got Mr Reid, KC, representing Bradford Rural Estates.
Good morning, madam. Yes, I'm here. I'm here with Mr Rouse as well, who's later down the list. So
you in the same room?
We are not in the same room.
Right, okay.
He's in another room.
Right, so, that's fine.
Yeah.
So Mr Rouse is next on my list. So if we turn now to Mr Rouse.
Morning. Good morning, ma'am. Good morning. Yes, so as Mr Reid has just said, I'm here in support of Mr Reid for Bradford Rural Estates Limited.
Thank you. And then next on my list, I've got Mr Maxfield from Raby Estate.
Yes, good morning, ma'am. Guy Maxfield from WSP representing the Raby Estates.
Thank you. And then we've got Mr Kells from CPRE Shropshire.
Good morning.
Morning,
ma'am. Yes, I will be dealing with the matters, and Mr. Green is here, should be with us as well.
Yeah, I've got Mr Green, I think, on the call as well, so I'll ask him next to just quickly put his camera on and say good morning, Mr Green.
Good morning, ma'am. Yes, that's me. I'm Charles Greens, here supporting Gerald today. His name's Gerald, not Gerard.
Oh, is it Gerald? Okay.
But Gerald will be the primary speaker for us today.
Okay, thank you. And then I've Dimitru Smith from Gladmans.
Good morning, Mum. My name is Victoria Dimitru Smith and I'm a senior planner from Gladman here today.
Thank you. And Joanne Harding from the HBF, the House Builders Federation.
Morning, Mum. I'm here as well, yeah, Joanne Harding, Home Builders Federation. Thank you.
Thank you. Hopkins from Stanmore Consortium.
Good morning, Mum. Morning. Mike Hopkins from JLL. I'm acting on behalf of the Stanmore Consortium. Good morning.
Thank you. Morning. And then Mr Carter, who's from the NHS Trust.
Yeah, good morning. I'm David Carter from Tyler Parks, representing the collective requirements of the NHS in Shropshire. Thank you.
Okay, thank you. And last but not least, Mr Pollard from Miller Homes.
Good morning, Mum.
Mom.
Anthony Pollard from Turley, as you say, representing Miller Homes. Thanks.
Thank you. Is there anybody on the call that I've not shouted their name out that wishes to take part? No? Okay, that's good. So now we've done the introductions, what I'll do, as we explained in the agenda we sent round, we thought the easiest way to deal with things today, given that we'd already had a session on the duty, and this is really just picking up the additional information that the council have submitted, rather than having a long series of questions, would be that we just deal with it in the round, because we tend to get repetition anyway when you have lots of questions on one topic. So the way in which we propose to deal with it is that if the council go first and set out any points they wish to make. Mr. Carter, if you can just turn your camera off at the moment, please. Thank you. So if the council want to go first and make any opening comments, summarise their representation, and equally if at the same time any of the Black Country Authority representatives want to say anything, and then I'll turn to participants on the call, and it might be that we sort of hear all the participants, then come back to the council. The council might want to deal with them individually. We'll see how it goes as we go along. Okay, is that okay, Mr. West? Are you happy with that?
Yes, Ms. Crosby, yes, we're very happy with that, and thank you for setting out the agenda so clearly. Shall we proceed then?
Yes, whenever you're ready, just
yeah, okay. Thank you, Mr. Crosby. I'll be relatively brief. I'm sure everyone will be pleased to hear that. Obviously, you have our matters statement in front of you, hopefully, and it's all been read, so I'm going to take it as read. So I'm not going to go over this overly today. I just wanted to highlight a few sort of key points sort of early on really on this one. Obviously, it's been alluded, it's already been mentioned in the introductions, but obviously what the first question on the list was around ABCA and where are they now with the issues which have happened since our last hearing sessions in July. So a lot has happened actually on that one. A lot of very important issues that the West Midlands are seeking to grapple with around plan making in the region on that point. So, but from what we are talking about here today and the issues which we are talking about here today, we do not think that has any relevance for what we are here today to talk about, you know, the legal duty. So that was my first point, but I'm glad to hear that that's already been mentioned already in the introductions. In terms of just sort of very broadly, I suppose having an overview of our position, the statement we put in was very much around the additional evidence we provided on request as a result of last July's hearing sessions. We acknowledge that the outcome of those of the sessions was a requirement to identify and to submit additional evidence to show those conversations that have led to the outcome of the exercise, particularly around the issues of housing and employment. That is why we put that bundle of information in September. So that is number GC15 A to I. So obviously it'll probably be referred to today. So when we're referring to that, that's the additional bundle of information. That is information which covers the council's cooperation with all our adjoining neighbours and with ADCA on that point, particularly around the issue of housing and employment. I think the main issue which we were discussing in July session was around that unmet need from ADCA. So we clearly highlighted that as a separate appendix, and that I think is Appendix A in the bundle of information we provided. But I do think in terms of coming to your conclusion on the council's meeting its legal requirement, we do have to take that with the other evidence we've provided as well, which you've already had as part of our examination. So that includes the compliance statement, which is EV 42. And also the various statements of common ground which you have in front of you as well. So if I just move briefly on to the questions you posed in your matters, issues and questions, and if I collectively take a few of them alongside each other for, I suppose, for brevity really on this one. Clearly, the first question we've already mentioned about ABCA and where they are and what implications, if any, there are of the cessation of the joint plan. Our view is that there are no implications from that. The reasons for that are that evidence and that cooperation was with the geographical area of ABCA. That continues, that exists, it's just not going to be planned for in the same manner. The evidence which was collected and is being used to influence that plan will be used to influence the separate plans and continues to be the best kind of avenue for exploring that issue of unmet housing and employment needs, in our opinion. And as you've already mentioned in your introductions, ABCA does continue to be an entity. I'm sure colleagues from ABCA can explore that a bit if necessary. In terms of the second question you posed about the how up to date the statements of common ground are, we would consider that all of the statements of common ground, including that with ABCA, are up to date. Again, for the reasons we've outlined, we recognise clearly that there have been some factual alterations with ABCA and the manner in which they are going to be planning, but the broad conclusions of the statement remain valid. And the important bits, in our view, the conclusions around unmet requirements of both housing and employment, and the offer of assistance, the agreed offer of assistance from Shropshire Council remains up to date. There is no question mark about that. With regard to the wider statements of common ground, because obviously we're dealing not only with ABCA but with a number of other areas as well, all those other areas with our neighbours remain up to date in our view. We have highlighted to you and to the examination a number of changes which have happened since our July sessions around some specific site allocations, and they relate specifically to the issues around the Clun catchment, around and particularly around a suite of national advice which was received at the end of last year. We are exploring the avenue on request by yourselves to update the statements of common ground with Natural England and the Environment Agency to reflect those changes. We do not know whether that outcome will result in any alteration of the statements of common ground, but it's just worth highlighting that that is an issue which we are exploring as a council with those agencies. With regard to a specific site allocation, which was referenced, I believe, in matter 1 of the hearing sessions, which is SHR 166, which is a proposed employment allocation for Shrewsbury. There was discussion at the July session around the potential for that site to be for Historic England to agree that that site would become a monument, a scheduled monument. We have now heard back from and that has happened. So clearly there has been a material change that we will need to deal with as part of that process. And we will be exploring whether that needs Statements of Common Ground update with Historic England on that point. We believe all those points we've just mentioned about those conversations which will be happening relate to the later part of the examination if we get there. They relate to site allocations and they do not in any way alter our legal compliance around the duty. But it was just to update you on the fact that because you've asked the question around the updates, there is a potential that those will be amended in before we get to the next part of the examination. If I just take collectively questions 3 to 6 now, which are primarily around housing and employment, and particularly around whether the new evidence we provides evidence that, in particular, that we have maximised the local plan, the effectiveness of the local plan. Again, we set out our case in the matters response. I'm not going to go over that here today, but all I would say at this point, we do believe that evidence that we have provided, GC15 A to I, shows clearly that those conversations were meaningful, they were constructive, and they happened throughout that plan preparation process, both with ABCA but with other neighbours as well. In terms of the outcome from those sessions and from those conversations, they are captured within the Statements of Common Ground that we have provided. But just as a few headlines, and particularly in relation to the issue of ABCA, the outcome clearly set out that there was a functional relationship with ABCA, with that area, with the geographical area of ABCA, that there was, as part of their plan making process, an unmet housing and employment land need, which was forecast within their plan, and the outcome, we determined an appropriate contribution towards that unmet need. We therefore are of the view that we have maximised the effectiveness of the local plan for those reasons. We've captured the outcomes within the Statements of Common Ground, which we feel is up to date and remains valid. But importantly, we'll also continue to have those conversations with our neighbours and with those constituent parts of ABCA as we continue to move on. And they will continue to have conversations with us as they move on with their respective local plans as well. I just wanted to make an additional point at this point. Now, I don't want to tread on the toes of other people who will want to have their sort of articulate their own arguments, but I think it's worth pointing out, and I think this was something which we had seen in the earlier session in July, that there appeared to be some view from some parties that the unmet need issue that we are seeking to grapple with was a solely Shropshire issue. It is not a solely Shropshire issue, it is very much a West Midlands issue. And this is perhaps evidenced most clearly within the bundle of information we provided, within the final piece of evidence that we provided in relation to the conversations with ABCA, which is a letter from ABCA from April last year, which I think you've probably already seen, but it's worth pointing out that that letter from ABCA is addressed to all their neighbours and authorities with a close relationship, so including Shropshire, but it also including those other parties as well. And it is clear from that letter that there is a on-running conversation with all those neighbours, and that unmet need, which is arising in that area, is a conversation happening and will be happening with councils across the West Midlands, not just with Shropshire. So I just wanted to make that point absolutely clear there. So just to conclude on that point, and particularly with relation to ABCA, Shropshire Council hasn't agreed an initial contribution. That is set out in the Statements of Common Ground. We do not see that as the end of the story. We believe that clearly future reviews of our local plan will continue to need to grapple with that issue of unmet need wherever that arises. We are not blind on that issue. We do believe we've set out a proportional and sustainable contribution. That contribution has been agreed both from a housing and employment perspective by ABCA and agreed by all of their leaders in the Statements of Common Ground, so all 4 constituent leaders of the ABCA councils, and that the work and despite the cessation of the joint local plan and the beginnings of the emerging separate local plans, that work around the duty and around those continuing conversations will continue between Shropshire and those constituent parts. So I will leave it there, because I did have something to say on minerals and waste, but having heard what Mr. Palmer said, Inspector Palmer said, I won't say anything about that, and I'll take that as read. So I'll pause there, and I'll hand it over to yourself.
Thank you, Mr. West. Do any of the participants want to speak? Mr. Cully, you've put your hand up, so I'll hear now from the representatives for ABCA. Well, it's still ABCA, I think, isn't it? Do you want to explain a little bit about that, Mr. Cully, what ABCA now is? And I think it's still in existence, isn't it? But in maybe a slightly different form.
Yeah, thank you, Mom. So absolutely. So ABCA predates the Black Country Plan. It existed before we started work on a Black Country Plan, and it still exists, and I would hope that it will continue to exist going forward. So yeah, as I touched on earlier, the authorities were unable to agree a way forward with the Black Country Plan in September, October of last year, but we responded quickly in light of the cessation of that work. So in a period following that time, so in November and December, the authorities brought forward local development schemes to set out how they would be preparing their own local plans. The final local development scheme, so for Dudley Council, which Vicky may wish to elaborate on shortly. So the Dudley local development scheme is due to go to Cabinet on the 26th of this month. So by the 26th of January, we'll have updated local development schemes for the 4 Black Country councils following the cessation of work on the BCP. We will, of course, need to be mindful of the potential implications of the government's consultation on planning reform on the 23rd of December, and how that might impact upon the programming and the approach that the individual plans take. But I think it's important to just to confirm really that the Black Country authorities did respond quickly to the cessation of work on BCP. The details of when those LDSs were brought into effect is in our statement that we submitted to the examination. There were just a couple of points really that I wanted to confirm. That was one of them, really, around the LDSs, and the second one was in terms of how the authorities will discharge the duty going forward, which Mr. West touched on earlier. And I think it's important to draw the examination's attention to, I suppose, the first of the new arrangements that we've used was in relation to the South Staffordshire local plan, the Birmingham local plan, and the Stafford local plan. So those were all out to consultation in November and December of last year. The individual Black Country authorities responded to those consultations. In the case of my own authority, City Wolverhampton, we took a report to Cabinet on the 14th September, which we can make that report available to the examination if that would assist. But I think that's important, because in that report we clearly set out that prior to the cessation of work on Black Country Plan, then ABCA had a role in responding to duty to cooperate consultations on behalf of the 4 authorities. That's set out in that 14th of December Cabinet report. Going forward, then, as I've touched on, the individual authorities will respond on an individual basis. ABCA could have a role going forward to provide a forum for the authorities, for leaders to be able to discuss issues of mutual interest, including the duty to cooperate. So as I said, ABCA will continue to exist, and it may have a role in duty to cooperate discussions going forward, but primarily that will be on an individual basis. So the individual authorities look forward to continuing the positive engagement that we've had with Shropshire Council over the preparation of the Shropshire local plan, and as the individual local plans of the Black Country authorities progress, then equally the individual authorities would look forward to a continuing positive engagement with Shropshire and other local authorities going forward. So I think Mr. West covered a lot of the background, but I just wanted to kind of touch on those 2 specific issues. If my Black Country colleagues wish to elaborate on those, then please do. Thank you.
Thank you, Mr. Colley. Do any of the other Black Country authorities want to add anything or say anything? Mr. Ball.
Thank you, ma'am. Yeah, only to say, as with Wolverhampton, Walsall have also submitted our individual response to the 3 local plans, South Stafford and Birmingham. Our responses were endorsed by our cabinet again in I think it was December. The fundamental issue, of course, is that the sort of fallout from the Black Country Plan doesn't change the overall housing need for the 4 Black Country authorities, and it doesn't change the contribution that we still need to meet our needs from neighbouring authorities.
Thank you, Mr. Ball. Yeah. Ms. Popplewell, did you want to say something?
Thank you, Mum. Just really to confirm, Dudley's got a cabinet report going next week, which Mr. Cully referred to, with our updated LDS. We've also got our responses to our consultation at the local authority consultations, including Birmingham, South Staffordshire, Stafford, which the same as Walsall and Wolverhampton. So they'll be going. We've submitted those as in officer responses for now, and they'll be going for formal endorsement at cabinet next week. And we will be progressing with individual responses, but working between joint 4 authorities on cross-boundary and duty to cooperate alignment. Thank you, Mum.
Thank you, Ms. Popplewell. So, Council, a quick question. So there's 4 authorities in the ABCA area, and we've got 3 here today. Obviously we've got statements. Is there a particular reason why the other ones not attended? Presumably it's not because you've fallen out with them and.
Not that I'm aware of. I don't think we've fallen out with them. No, I don't know why they're not that. They're not normally represented in this type of agenda, but perhaps Mr. Cully will be able to kind of elaborate on that.
Thank you, Mark. No, we've not fallen out. So Sandwell were happy for the 3 of us to speak on their behalf today. Thank you.
That's fine. Thank you. Okay, I have no further questions. Did you want to add anything else, Mr. West, before I take comments from participants?
No, I think I'm okay at the moment. So obviously we'll be very happy to respond to any questions you have or anyone else has as well about that. So I'm interested to hear what people have to say now.
Thank you. So if people want to put, and I'll take, and then what happens is it will put you in an order of who put your hands up first on my screen, and I'll hear from you in order. Okay, so first we've got Ms Rawlins.
Thank you, ma'am.
Okay.
In fact, thank you for the presentations. I'm here today, as I said earlier, on behalf of Shifnal Matters, Shifnal Town Council and Tong Parish Council. And we have particular concern around the uncertainty that's been created as a result of the collapse of ABCA, and also these new planning reforms and the implications of this on the individual local authority plans, and how this will implicate the unmet need requirements and the consequential greenbelt release that would result. Hopefully you've had my statement, read my statement, but just to pick out the main points from that, if I may. We were aware that the statement of common ground was specific with ABCA and not for individual authorities, so we just wanted to highlight that. We were also aware that Shropshire Council indicated that the unmet need would be met across the county, not on a specific site. However, there does seem to be some tension there in terms of some of the responses that have come back from ABCA, and a recognition that the eastern part of the county does appear to be functionally well related to the Black Country areas, and a recognition that some of the allocations and land safeguarded would be contributing towards that overall unmet need. So as a result, our view is that anything around unmet need has a specific reference back to Shifnal, and that we just wanted to clarify that. So our view is that following the collapse of the ABCA work on the joint Black Country local plan, the work has now ceased, and we're aware now, as we've heard today, that the LDSs are now in place, and work is starting on the joint plans for the individual authorities. I think our concern is that the failure of the ABCA authorities to agree a joint way forward suggests that the formal cooperation that was needed to undertake a joint local plan has deteriorated. And this must have implications, as far as we're concerned, on the surrounding authorities, as any statements of common grounds or other duty to cooperate discussions must now be considered to be based on what we consider as far weaker evidence. It cannot be assumed that what was discussed and submitted on behalf of ABCA will still apply for the individual authorities. Given the recent events, the ABCA statement of common ground, as far as we're concerned, is no longer relevant, cannot be taken into account as evidence supporting Shropshire Council's proposals consequent upon their duty to cooperate responsibilities. It cannot be relied upon, cannot be scrutinised or verified, given ABCA is no more, and it cannot be taken forward with any confidence into the draft Shropshire local plan. Moreover, given the individual Black Country authorities do not yet have their own local plan in place, which have not been advanced to any meaningful stage and have not been subject to any level of scrutiny, then we feel that weight cannot be attached to their representations at this time either. It cannot be assumed that what was considered relevant and appropriate for a joint organisation will still stand the test of soundness when each authority will now be following its own planning agenda, objectives, evidence and interpretation of any evidence that's there to date. And we regard this as being particularly important and of particular relevance, given Shropshire Council's unmet need proposals have a significant effect on Greenbelt in the east of the county, like I referred to at the beginning, and proposals at Shifnal. In view of this reliance on Greenbelt release, and it's even more important and relevant that we need to prove exceptional circumstances, and that such a release is based on robust evidence and sound justification. We'd also want to raise the point about the planning reforms and the uncertainty that brings. So we've got uncertainty around sort of the individual authorities and how they'll interpret evidence. We've also got uncertainty around the recently announced planning reforms that are out, as we talked about, on consultation. Without going into any detail, I'm sure you're all familiar with them, but they clearly relate to housing numbers, greenbelt boundaries. The statement on greenbelt boundaries are not required to be reviewed and altered if this would be the only means of meeting the objectively assessed need for housing over the plan period. And there's also talk about replacing the duty to cooperate with a new alignment policy. So I appreciate these are all out to consultation at the moment. However, you know, it does travel, and particularly the relevance to greenbelt and housing numbers, and therefore, you know, it'll be something I'm sure that the individual local authorities and their individual plans will be reflecting upon. Our view is, given this changing context to the Shropshire local plan around the collapse of ABCA and the emerging planning reforms, we're of the view that no confidence can now be attributed to the outcomes of the ABCA Statement of Common Ground. And as a result, Shifnal Matters, the Shifnal Town Council and Tong Parish Council request that the contributions of the 1,500 homes and 30 hectares need to be removed from the Shropshire local plan with immediate effect. As far as we're concerned, this would then allow the Shropshire plan to progress, because it's at an advanced stage now, it's at its examination, so it can proceed with a greater level of certainty through the examination process with regards to its meeting its other housing and employment requirements to meet its own local needs. This would then enable the authorities of Dudley, Sandwell, Walsall and Wolverhampton to progress their individual local plans informed by their own evidence bases, without any implications in terms of what was previously agreed with Shropshire, because clearly there's a need figure there. There's 4 individual authorities doing individual plans. How will this amount be agreed between those 4 authorities? So taking it away just creates more certainty. Preparing these individual local plans, you know, in Statement of Common Grounds, we've heard there's LDSs in place, but given sort of the landscape we're now faced with, will take time to achieve, in our opinion. And we believe that a future review of the Shropshire local plan would present, you know, a timely opportunity to then take on board more robust information from the 4 authorities that will have progressed through their individual local plans. And then as such, if we're removing the additional requirements, then those that I represent would also like to see the related significant, in their opinion, safeguarding allocations and allocations around Shifnal that are relate to unmet need to be removed from the plan. That's probably my main points that I wanted to raise. Thank you.
Thank you, Ms. Rawlins. Do the council want to particularly comment on anything that Ms. Rawlins has said, or do you want me to move on to the next speaker?
Yeah, I think we just want to come back on a couple of points. Again,
yeah.
Just for brevity, really, on this one. Just a couple of sort of pragmatic points. Obviously, you've heard our view on why we feel as though the Statement of Common Ground is up to date and valid, and that argument is surrounding about the evidence base which is in existence, which will influence the emerging local plans in the ABCA area. So we feel as though that evidence remains up to date and valid. I would also point out that the fact that the Statements of Common Ground that we agreed was signed by all 4 leaders of the councils of those 4 constituent parts. So there was an agreement with the individual areas as well on that point. So it wasn't. So I think there is reassurance that there is a continuity there, even though the the circumstances around plan making have changed, and I freely admit the timings have changed as well. They will be further behind us than they are now, but I don't think that reduces the impact of the evidence that is in play at the moment, principally around things like urban capacity assessments, etc., etc. So I just wanted to make that point, and I just wanted to also make a point, really, just because I didn't mention it in the introduction, about the manner in which Shropshire Council is proposing to accommodate this need, and it was discussed at length at the July hearing session. So I haven't mentioned it up until this point, but obviously, you know, we are not relying on one single allocation to accommodate this unmet need. Our proposal is effectively to bake in, I suppose, that unmet need within the spatial approach that we've undertaken at Shropshire Council. So there will be undoubtedly a role for areas within the east of the county with a greater proximity to that the APCA area, and including Bridgnorth and Shifnal, but there will be other areas as well, principally potentially for Shrewsbury as well, around that as well. So I think it's not just a case of this unmet need equals Greenbelt release on that one. And you know, I will perhaps point out, and it is worth pointing out from a housing perspective, this local plan is identifying one single site for release of Greenbelt for housing within the up to 2038, the end of the plan, which is a single site in Alverley for 60 dwellings. Okay, there are no other proposed Greenbelt releases for housing to be accommodated in this local plan. Yes, there is future proofing, as has been mentioned by Mr. Rawlings, but that is not Greenbelt release in this. Here's the time. Greenbelt is for delivery in this local plan, should I say. So those are just a couple of points I just wanted to make there. I did want to hand over to Mr. Richards, who's got a couple of points from a legal perspective.
Yes, thank you, Madam. If I may say so, Ms. Rawlings' submissions to you illustrate the difficulty of separating out matters concerning the legal duty to cooperate and cross-boundary matters that go to soundness. She even said at one point it wasn't sound to continue with the 1,500 houses and 30 hectares. And she, on behalf of her clients, in effect, wants that removed from the plan. That's a soundness issue. I didn't actually hear anything from her that went to the legal duty as at the date of submission of the plan. And I think that's important to bear in mind. Others have fallen into the same trap, and I shall have more to say in response to at least one other speaker in due course. Thank you.
Thank you, Mr. Richards. I'll bring in Mr. Reid now.
Thank you very much, Mrs. Crosby.
I just ask Ms. Rawlings if you turn your camera off, please. Thank you. Mr. Reid.
Thank you very much, Mrs. Crosby. You, of course, have our further representations in respect of this hearing and the appendices that are included within those, and those appendices incorporate a second opinion from me. And I'll be dealing with a number of matters arising from that document, and what I'll do, Madam, if I may, is just give you the references as I go through so that you know what I'm talking about at which stage and where you can then find those various matters within that document. I'm going to focus this stage on the discussions and the DTC compliance issue in respect of the Black Country Authority, as you probably expect. And so all of my factual points are going to be related to the documentation that's been presented by Shropshire in respect of those discussions. and I'll be making specific reference to those in a little while. I just want to give you an outline of what I'm going to do. Firstly, I'm going to revisit some of the points of approach in the knowledge, of course, that Mr. Richards, when he says that he's got lots more to say about somebody's representations, he's talking about mine, of course. I'm going to deal with that firstly in terms of a matter of approach. Then I'm going to deal with some general issues, the general points that establish that the DTC has not been satisfied in this case. And then I'm going to go and deal with some of the specific documentation that's been presented by the council in their additional information. But I can say at this stage, and you probably are expecting it, that nothing that's come out of anything in that documentation establishes compliance with the DTC. Absolutely nothing, and I'll show why at a later stage. But before doing so, if I, as I say, deal with the matters of approach, the first of which I'll go back to the principal point, the focal point of the discussion, and that's under section 33A of the 2004 Act. And which sets out, of course, the duty, which is, as Mr. West said, is a requirement to maximise the effectiveness of the preparation of development plan documents. And of course, as a result of that, it's necessary to see subsection 2, and you'll find this in paragraph 6 of my second opinion. Subsection 2 is a requirement to engage constructively, actively, and on an ongoing basis. Now, I'll go on to look at that in a moment in the context of inspectors' reports. But I'm going to deal with Mr. Richards' point that really my focus is on question of soundness. And he's wrong about that for the reasons I set out previously in July. But I want to reiterate why. First of all, if we look at the MPPF, and my reference here is to paragraph 9 of my second opinion. The MPPF, paragraph 11, in the context of plan making, makes absolutely clear that there should be the provision of objectively assessed needs for housing and other uses. Here, of course, we're looking at employment as well as housing, as well as any needs that cannot be met within neighbouring areas, unless there's a strong reason for not doing so, say, for example, Greenbelt or any other matter. But that is the requirement, an overarching requirement, as I said last time, that there must be the provision of the objectively assessed needs of other authorities unless there is a strong reason for not doing so. Now that is, of course, an issue around soundness, without doubt. But Mr. Richards' point is a banal point, if I may say it with the greatest of respect, because the DTC discussions go to the question, ultimately, of soundness. In short, the purpose of the DTC discussions is to arrive at a plan in overarching terms that is sound. So it's not exactly surprising that the focal point of a discussion between two authorities should be around those matters that are identified in the MPPF that need to be arrived at or need to be achieved in order to get to a sound plan. So the overarching point, I want to say this before I go on to that overarching point, that the council, of course, hasn't objected to anything I've said in any of my opinions on the law. It hasn't presented any other inspectors' reports to identify any case to establish that I'm wrong in what I say with regard to how the DTC must be framed. That's to say, to how the discussion should be framed. Nothing at all. And so I'll wait to hear what Mr. Richards has to say, but he certainly has no other documentation to support his case. But given that that is the ultimate test that one needs to look at in the context of paragraph 11, the aim must be to provide for any needs that can't be met within a neighbouring authority's area unless there are strong reasons for not doing so. And the discussions need to focus upon that issue. I'll come back to that in a moment, but and as to how that should be both evidenced and then looked at in terms of a matter of approach. But before doing so, can I just flag up a number of other references? The MPPF again, paragraph 35A, and it's in my second opinion, paragraph 11. So paragraph 35A, which deals with the issue of soundness, it needs to be positively prepared. and it needs to include a strategy which, as a minimum, seeks to meet the area's OAN, but is informed by agreements with other authorities so that unmet need from neighbouring areas is accommodated where it's practical to do so and is consistent with achieving sustainable development. And that, of course, is a reference back to paragraph 11. That's to say the ultimate test. So it draws together not simply the document's approach towards delivering development, but the nature of the discussions that should be had between authorities. And that approach, if there's any question mark as to whether, look, you have to separate out DTC, which is just a matter of discussing things, from the overarching approach with regard to soundness, is dealt with, I say very clearly, in the context of paragraph 35C, which is dealing with the effectiveness of development in the of a plan in the context of soundness. And it says that it needs to be based on effective joint working on cross-boundary strategic matters that have been dealt with rather than deferred, as evidenced by the statement of common ground. And so what one needs to establish is the joint working in order to arrive at an effective strategy that is also one that is positively prepared. You can't divorce the two. And the next reference I have, which is in paragraph 14 of my second opinion, paragraph 61, is that, and it says, in addition to the local housing need figure, any needs that can't be met within neighbouring areas should also be taken into account in establishing the amount of housing to be planned for. So there is, on the face of it, a taking into account of those particular figures. And what taking into account obviously means is taking into account for the purposes of the NPPF, which takes you back again to paragraph 11. And the final reference, at least in the NPPF, is paragraph 66, the para 15 of my second opinion, which says this: strategic policy making authorities should establish a housing requirement figure for their whole area, which shows the extent to which their identified housing need and any needs that cannot be met within neighbouring areas can be met over the plan period. And of course, that phrase of can be met and cannot be met is again a reference back to paragraph 11. Now, before going on to deal with some of the inspectors' approaches to this, in order to establish that what I say as to the proper approach with regard to the NPPF is the correct approach, can I just flag up two other references for you, please, Madam? The first is in paragraph 22 of the PPG, which is in paragraph 22 of my second opinion, actually, which deals with the sort of evidence that needs to be presented, and I'll come back to that. But the authority will need to submit comprehensive and robust evidence of the efforts it's made to cooperate and any outcomes achieved, and it will be thoroughly tested. Of course, you know that test, and that includes, of course, by reference to any necessary discussions. And the second reference is the observations of the late Mrs. Justice Patterson in the Central Beds case. It's paragraph 20 of my second opinion, which flagged up, I won't quote it at this stage, but just flags up, to say this, that it flags up a requirement there should not be a mechanistic acceptance of documents, but a rigorous examination of those documents and the evidence received in order to reach a planning judgment, for you to reach a planning judgment on whether there has been active and ongoing cooperation. And those two matters, as I say, I'll come back to in a moment when I just deal with the overarching principles that need to be looked at by you and Mrs. Dillon when reaching a conclusion as to whether the DTC has been satisfied. But before that, as I say, the inspector's assessments in other examinations and the approaches that have been taken, and I've set these out again in my second opinion. Firstly, paragraph 23 dealt with the Chiltern and South Bucks local plan, where Inspectors Birkinshaw and Troy in 2020 indicated their concerns that there wasn't any detailed analysis, this is what they say, any detailed analysis as part of the plan's preparation to determine whether or not the adverse impacts of contributing towards a neighbouring authority's unmet needs would significantly and demonstrably outweigh the benefits. And so it brings the whole question of discussion back to the test within paragraph 11 as of course it then was. The second reference is to the central beds examination and Inspector Cook's conclusions in 2015, paragraph 24 of my second opinion, where it was said that there's no evidence that the council has considered the implications of meeting the unmet need of the neighbouring authority in full. And then finally, the Castle Point examination in 2016, where Inspector Smith, and this is paragraph 25, Madam, for my second opinion, said this. Rather, there's concerns about the way that the approach was taken, that engagement under the DTC should seek to bring about the outcome set out in what was para 179 of the NPPF then, albeit no duty to agree, but to bring about the outcome in 179. And you'll see in the old NPPF, again, I've quoted it in my second opinion, so you can see that. But that says that joint working should enable local planning authorities to work together to meet development requirements which cannot be wholly met within their own areas, for instance, because of a lack of physical capacity, or because to do so would cause significant harm to the principles and policies of this framework, which is essentially that phraseology now contained within paragraph 11. So what that means in practice, and what I say needs to be focused upon, rather than just general statements about, well, we've complied with the DTC because we've discussed, what needs to be focused upon is firstly as to whether there is the detail in minutes and other documents to show the nature of the discussions between the relevant DTC bodies. I'll just say at this stage, there's no question, but that the ABCA authorities are, for the purposes of Para 11 and for the purposes of DTC, neighbouring authorities that there should be discussions with. No question over that. So that's the first matter that needs to be looked at. Second is that there needs to be evidence to show that the proper approach for discussions has been focused upon. And what that means is that there should be discussions around why the full amount of the outstanding needs of the neighbouring authority cannot be met, or why the amount that is offered is the most that can be met. In short, it's a discussion to see whether and how the various hurdles to the full delivery can be overcome. That's what needs to be identified by way of discussions. Because otherwise, you're looking at the question of the discussions in the ether without any reference point. And the reference points are very clearly set out, as I say, in the NPPF. Now, lots has been said about, well, there's going to be changes to the NPPF, potentially through the consultation process. It's totally irrelevant. Irrelevant not only because the DTC is at the stage of submission in September 21, but also irrelevant because at the moment they're consultations. They're not the subject of any determined policy. Or any challenge to them, I should add. And insofar as, if at some stage there is a greater weight, well, that will be of relevance to the question of soundness, but not to the question of the DTC. So, as I said, I wanted to then turn to the next part of my submissions on this point by reference to the sort of general points rather than going into the specifics. I'll come on to those in a moment. And as is probably unsurprising, my first point is that there is on the face of the evidence the incorrect basis for discussion. And in short, there is no reference to the NPPF test and no analysis or discussion around the connotations of that test. And that is essentially a systemic error in terms of the discussions between the council and ABCA. And I say at this stage that the fact that there has been agreement between ABCA and the council as to the compliance with the DTC is irrelevant if ultimately they haven't applied the proper test. The fact that ABCA are not here saying, well, we don't agree with the DTC conclusions of the council doesn't affect the substance of my submissions. They, in short, can't get over the problems by virtue of the fact that they both think that they have discussed the issues. Put simply, it's because they haven't adopted a proper approach. And if they haven't, both of them adopted the proper approach, then the DTC fails. And as I say, it's necessary to look to see how, in discussing matters, the authority has sought to arrive at a conclusion that either it cannot deliver the total amount, having properly assessed that, and grappled with reasons as to why there should be some lesser amount and what that lesser amount should be, as I say. And I said in my first opinion that the council had, on the face of the housing and employment topic papers, failed to comply with the proper approach towards the discussions. And I've also said that now in the context of my second opinion at paragraph 30, because on the basis of the evidence, it's absolutely clear that they didn't undertake a proper approach. And I'll set out the reasons why. First, there's no evidence of any investigation, discussion, or engagement concerning the connotations of providing for the full need or the factors showing that there should be a lesser amount. No evidence at all. There's no evidence of any discussions to achieve any proportion higher than the notional figure that has been put forward, as to say the notional figure of either 1,500 units or 32 hectares. No discussions around that at all have been evidenced. Next, the notional figures themselves bear no relationship to any discussions. You can't tie them to any form of evidence or any evidence as to how they've been arrived at following discussions or as a part of the discussions between the authorities. I should say there's no suggestion in terms of the additional documentation that's been presented in its summary form as opposed to the actual substantive evidence. No suggestion within that document that the council had actually considered the effects of delivering the whole of ABCA's unmet needs. They don't even suggest that they did. Or what lesser provision beyond the 1,500, what lesser provision they could sustainably bring forward. And actually, the reason is, the reason you can't find any of that is because of what I set out in my first opinion, namely that the basis of the council's approach is that they thought there's no methodology for discussing the DTC. You'll recall the various references in my first opinion to that. But of course, there was a methodology and it's contained within paragraph 11, as I've said before. It's just that the council didn't realise that that's what they were supposed to be doing. The next overarching point I'd make is by reference to, these are the references, Madam, it's the housing topic paper and the employment topic paper. Firstly, the housing topic paper, paragraph 3.113, and then paragraph 6.77 of the employment topic paper. And those are GC4 little I and GC4N for November, respectively. And you'll recall there that the council said, well, there are a number of issues that they had discussed with ABCA, and you'll recall the various factors, no doubt. They're A through to H, and they're repeated verbatim in both the housing topic paper and the employment topic paper. And they deal with matters like the proposed strategy for the level and distribution of development, the interplay between the proposed spatial strategy and any proposal to accept a proportion of unmet need, the known constraints that exist in Shropshire, particularly those elements of Shropshire in closest geographical proximity to the Black Country, known opportunities, etc., etc. I could go on through the list, but Madam, I won't take up time going through all of them. You'll no doubt have time to read through those at your leisure, and you'll be able to see that I've flagged this up in my first opinion as well. But there is no evidence at all that these were ever discussed in any of the meetings between the two authorities. There's no evidence of the results of discussing any of those points, i.e. what were the conclusions that were arrived at and how did they lead to the decision that you shouldn't be arriving at a higher figure than 1,500, but should be keeping it at 1,500. How do you tie any of those conclusions to the ultimate conclusion that 1,500 units was an appropriate level of provision in the light of what they were supposed to be getting to, at least by way of discussion? So what I said in both those opinions is right in my submission, that actually there was no evidence that they had actually discussed those, and the reality is that they didn't. The next point is the Greenbelt topic paper, which is referred to in paragraph 35 of my second opinion. The reference is GC4G. And this deals with the point that was flagged up a little while ago by the council when saying, well, you'll recall that in order to deal with one of Shifnall's points, I think Mr. West said, you'll recall that the housing numbers are going to be accommodated within the overarching need calculation or overarching housing requirement that Shropshire has settled upon. And I said previously that there's been no analysis of the effects of delivering greater amounts of housing from the Black Country Authority within Shropshire. And I said that previously, if you recall, by reference to the Issues and Strategic Options paper, January 2017, and the reference is EV 003.04, where I said, well, look, there was a high growth option that had been analysed at 28,750, and they never looked beyond that. And it's quite clear that they didn't look beyond it. But for the purposes of EC, there's been no further evidence disclosed to show that they had discussed this question with ABCA in order to see what the sort of hurdles there are around the delivery of higher numbers of housing within areas as yet unprovided for within Shropshire. So you just can't again tie what has been identified by way of the housing requirement to any discussion around the DTC between the two authorities. So those are the general points, save for one other, which relates to the statement of common ground between ABCA and the council. Now, of course, as I said earlier on, they've said that, well, there's compliance with the duty to cooperate. But if you look within the statement itself, it doesn't focus on any of the questions that I've asked or that I've set out as being the appropriate questions to ask at all. Just cannot find that. And is really simply a mechanistic statement of what ultimately the councils have agreed is the figure that should go into the plan at 1,532 hectares. So in the light of that, Madam, can I go on to deal with the specific points? And I've got 5 specific points on the evidence that I'll address. The first of which are the Greater Birmingham Black Country housing market area working group meetings. Now, you'll have seen within the relevant section of the ABCA bundle, and I'll give the page references, a large number of working party minutes. And one reference is page 81, for example. You have a look at that. And the first point to note, of course, is that there are large redactions that have been undertaken to those minutes. I don't purport to indicate why it might be that they're redacted. There's no explanation as to why they've been redacted. What we need to do is identify from the situation or post those redactions what we're left with. And actually, we're left with nothing to indicate that there was any discussion around any of the pertinent issues between the Black Country authorities and Shropshire. Just simply nothing. And I should say, you can't find anything in the additional documentation presented by Shropshire to indicate why they rely upon it. That's my first point. The second point concerns the meetings between Shropshire and ABCA. And you'll have seen that there are in the papers a large number of meetings being suggested between the parties. There are various Teams invites being there have been various Teams invites that have been presented in the evidence. But there's no records of what actually was discussed in any of those. And if you look at page 189, for example, of the bundle, you'll see there's an email of the 15th of July 2021. And this is what it says. Many thanks for the useful and constructive discussion today regarding the progression towards agreeing the statement of common ground and confirmation that upon agreement at your board on 28th of July that the duty to cooperate between Shropshire and the Association of Black Countries on behalf of the Black Country local authorities would have been fulfilled, subject to our council approval to proceed to submission on the draft local plan this summer. I will consider your proposed amends and respond by Tuesday 20th of July. We just simply have no other record beyond that. Nothing to indicate what was the subject of discussion. And again, if we look at page 63, going a bit earlier on in the chronology. Page 63, Gemma Davis on behalf of Shropshire to Ian Cully. Good to talk with you yesterday afternoon. I will update our cabinet members this afternoon and let you know when this is completed. This is the response. Now these are documents. It may be said, well, they're not actually showing very much because not very much was discussed. That might be one of the points that's made. But these are the discussion. These are the documents on which the council relies to show that the DTC was complied with. So we can assume, therefore, that they must have some substance. If they do, they obviously show nothing. And if they don't have anything relevant to say about the DTC, well, they shouldn't be in there anyway. So on either basis, there really is nothing from those various sorts of statements. And there are many others, I should say, as you'll no doubt see when you go back over the documentation, many others that indicate that there were discussions, but no understanding can be gained of what was actually said. The third point is the housing position, and what I say is a complete lack of discussion as to how one could meet those paragraph 11 tests, i.e. the full extent of the need, subject to strong reasons indicating otherwise. And the first reference I've got is at page 58. I'm going to go a little into the detail of the documentation so you can see how the discussions have developed, if I may, Madam. So the first document is of the 26th of April 2019 from Ms Davies. And I'll just summarise the position, if that's helpful, Madam, if that's what would be a sensible approach. But basically, what was being said in that documentation is that if they were going to be able to make a positive recommendation with regard to Junction 3, they need some publishable evidence, basically, and they listed the sort of evidence that they needed. In the document, it included a review of the strategic green belt within the Black Country and South Staffs and other matters, but all related actually to the position within ABCA, not anything with regard to Shropshire. That then was replied to by Mr. Cully on the 13th of May, and that can be seen on page 60, where the various documents were presented, and it should be said, an indication made within that document that, just bear with me one moment. top of page 62, a reference to the strategic opportunity at Junction 3 of some 50 hectares of employment supported by a provision of 3,000 homes, that being something that can contribute. So that even at that stage, they were saying, well, look, you know, that's what needed to be looked at, if nothing else. Then page 66, which deals with an email of the 11th of July, where you can see they say that's to say Mr. Cooper, on behalf of Shropshire, who was writing to Gemma Davies, also within Shropshire, saying that they felt that there were matters went very well, able to deal effectively with the questions, had a very productive meeting with colleagues from the Black Country. Today their shortfall looks set to increase, and you can see what's then said. But there's nothing within that that indicates any further discussion with regard to how Shropshire should be considering the level of need and whether it could deliver anything less. There's then a further letter of the 9th of September 2019. So a couple of months later, on page 73, I should say. Again, a letter, I think, from Mr. Cully. No, this time from Ms. Ross. And there was a further reference, actually, to even at that stage, the need to consider Junction 3 as being an important site to consider. But in overall terms, it was reiterating the need to deliver the total amount, or reiterating the importance, rather, of delivering for its part its needs within other authorities' areas. And then what we have in terms of the chronology is in terms of substantive chronology, a letter of the 12th of July 2020 from Shropshire, and that's at page 96 in the bundle. So basically 10 months later, where apparently there had been discussions, and that then led, that's the letter that offers the 1,500 units, the housing units. So 10 months later, with apparent discussions, literally nothing to indicate what the nature of those discussions was, there was an offer. And that is a clear and apparent failure in, if nothing else, the evidential requirements to deliver the evidential requirements of the DTC. But actually it discloses something far worse, which is that substantively there's nothing there that identifies any engagement with the relevant tests as I've set them out. And that point about there being statements around discussions being had between the parties, is something that one can find in the 20th of July committee report, cabinet report on the part of the council. It's a page 126, where again the question of the amounts of housing that were being provided for is dealt with at 5.7 and 5.9. Excuse me. Apparently discussions, but nothing there of any substance to indicate what was being discussed. So on the face of all of that documentation, one can see in the context of housing that there was no evidence of any discussions around the relevant focal point, as I've set it out. So the fourth point is employment. I can deal with this a little more briefly, actually, because of the lack of discussions that there were. If you turn to page 154, Madam, or at least this is the reference if I give it to you, it's the 29th of September 2020 email from Mr. West to Mr. Cully, and the what that's dealing with is a draft letter. Now, that draft letter I looked for, but I can't find the draft letter. It may be that I've missed it, and I apologise if I have, but it doesn't much matter. What it does deal with is, well, the sort of wording that Mr. West was sending over to Mr. Cully for his observations on. And what it was basically saying was, well, in terms of employment, Shropshire Council will be willing to consider the potential for delivering an element of unmet need. So that's the sort of substance of it. And then subsequent to that, the next day, actually, there was a letter written by ABCA, and it's on page 157. Page 157, it's the 30th September letter, where ABCA are saying they're concerned that there's been no provision for employment in the Shropshire plan. And then we don't have any further evidence of any discussions. What we have, though, is page 167. The committee, it's a cabinet, another cabinet meeting of the 7th of December, as I say, and within that document, at page 176, it's then indicated that there will be an offer in principle. And if you look at 5.24, 5.25, or indeed any of the other earlier paragraphs in that section, 517, you'll see no evidence of any discussion whatsoever as to why it is that it's appropriate to settle on that particular figure rather than any others. What we actually know as a result of that there were none of those factors identified in the employment strategy topic paper, those factors I've flagged up earlier on, none of those were discussed at all. What's apparent is that once that offer was made, in the same way as once the 1,500 houses were offered, there's no evidence of any further discussion in order to see whether or not actually something more than that should be provided for and why it is that something less shouldn't be. So no building on that immediate, on that initial offer. And that's particularly apparent in the context of the employment strategy. You just can't find that sort of analysis. What we do, though, know is that at paragraph 178 of the report, that cabinet report in December, it was decided ultimately that Junction 3 should not come forward. But interestingly, it was an analysis ultimately reached on the conclusion of there not being insufficient justification to release Greenbelt land, just on the basis of exceptional circumstances. Nothing with regard to the reasons why, in terms of a substantive analysis, a greater amount shouldn't be provided for, at least in Junction 3. But I don't have to rest my case on Junction 3, and I don't, because the whole question needs to relate to the totality of the provision in the way that I've asked you to look at it. My fifth point, final point on this, is the statement of common ground. I flagged this up to an extent, but what you will see if you turn to, I think, almost the last page of this bundle of documents, at page 190. Page 190, a draft SACG. And I've assumed that the draft of the statement of common ground, this is between Shropshire and ABCA. The draft that's referred to here on the 30th of June 2021 is something that doesn't markedly change the ultimate statement of common ground that was entered into. But what it says is, in that email from Mr. West to Mr. Cully again, he attaches this statement of common ground, which I feel he says sets out the current position with our duty to cooperate conversations. So we know that all of what they say they substantively did discuss is contained within the statement of common ground. And as I say, you can't find any of what I say needs to be identified within any of the other documentation. So it is perhaps right that the duty to cooperate statement does nothing more than set out the conversations, because they don't amount to anything. So that those are my 5 points. I just want to deal with 2 other points, if I may, Madam. I know I'm taking time, but I think I'm in fact the only person who is saying that there isn't a compliance with the DTC. I think so. It may be that you'll give me a bit of leeway in the light of that.
Do you know how much longer you're going to be, Mr. Reid? I'm just conscious of the time. I said we'd break at 11, but
thank you, Madam. It will be about 2 or 3 minutes.
That's fine. We'll just carry on. Yeah.
Thank you. The first point is this argument around the council making an initial contribution. If you recall, that's being said by Mr. West, and it's something that they specifically set out in their 16th of September 2022 letter, introducing this this documentation. And my first point is that that's an obvious after the event justification. There's nothing in the DTC discussions to indicate that it was an initial provision that would then subsequently be revisited. My second point on this is that actually, if you looked at the reality of the position, see page 97, there's a letter from the council of the 12th of July 2020. It's the one that made the offer. Actually, it was identifying that there would be, on a review, a pretend to reduce that offer, not to increase it. And my third point is that even if it is factually correct that it was an initial offer, it needs to be an initial offer that reflects the proper discussions. And if you haven't started from the right point, then you don't know whether or not that initial contribution is an appropriate one, as a proper proportion. Those are my points on that issue of an initial contribution. The next is these other documents that are relied upon by Mr. West to satisfy the DTC. He referred, of course, to the Statement of Common Ground and the Statement of Compliance. And in the Statement of Compliance, again, you'll see nothing that provides any sufficient evidence to meet what I've said. Then finally, if I can, just to deal with Ms. Rawlings' points, I couldn't, in the end, I say that I was the only person who was making the case on DTC. I don't know whether as a result of what she said, she's saying that the DTC has failed. But irrespective of that, the points that she's made are really ones that go to soundness rather than the DTC. So I simply make that point. But Madam, those were the various matters that I wanted to raise, and I'm grateful for your forbearance.
Thank you. So it's just coming up to 11:15. So if we break until 11:30 and then come back and we'll hear then from the council, I'm sure we'll want to respond to Mr. Reid's points. Yeah, so if you can keep your microphone, turn your microphone off and your camera off, but stay logged in so Kerry doesn't have to log everybody in after each break and lunchtime, etc. Okay, thank you.
Thank you, ma'am.
We'll just wait a minute.
Yes, Madam, it's going to be me to start. Hugh Richards of Council. The starting point is that learned friend Mr. Reid and I are on the same page. We both started section 33A, where we know that we're trying to maximise the effectiveness of the DPD process, and we know that the requirement is to engage constructively, actively, and on an ongoing basis. And as Mr. West will explain to you in due course, much of the evidence that we submitted in response to your request was to demonstrate that there was indeed engagement, which was active and ongoing. The other point that we, where Mr. Reid and I are in agreement, is subsection 7 of section 33A. That's to say that the council must have regard to any guidance given by the Secretary of State about how the duty, that's the duty to cooperate, is to be complied with. And we both agree that the guidance is found in the NPPF and the planning practice guidance. Indeed, there is a myriad of guidance on plan making. Here, for this session, what we and what you need to do is to distill out from all of that guidance, what is the guidance that relates to the duty? Not guidance on soundness, not guidance on environmental sustainability. What's the guidance that relates to the duty? Or what's the part of the NPPF and the part of the PPG that relates to the duty? Starting with the NPPF, Mr. Reid, in his second opinion, refers to paragraphs 24 to 27, and I agree, we agree. That is guidance relating to the duty. It would be hard to argue otherwise, given that that section of the NPPF is called maintaining effective cooperation. But in it, paragraph 24 simply sets out that the duty exists. It doesn't tell us any more on how to discharge the duty. Paragraph 25 sets out what the relevant strategic matters are, or that they should be identified. Here, we know that what was identified was housing and employment. So Mr. Reid can have no complaint about that. And that there needs to be cooperation with strategic plan-making authorities. Now, how strategic plan-making authorities do that is a matter for them. In the context of this case, there is no bar or prohibition on cooperating with the Black Country authorities through ABCA. Indeed, it was sensible to do so, because where hitherto the Black Country authorities have a history of joint plan making, they've got an existing joint plan in place. Secondly, ABCA was the body that Shropshire Council was asked to deal with, so it seems reasonable to deal with them in that circumstance. And thirdly, ABCA is the body which has been making representations on plan making in the sub-region and the region for many years. So that, for example, in the production of the current Birmingham local plan, ABCA was the body making representations and engaging with Birmingham City Council on the Birmingham plan, just as they have done hitherto with the Shropshire plan. And then paragraph 26 of the NPPF is next, And in particular, joint working should help determine where additional infrastructure is necessary and whether development needs that cannot be met wholly within a particular plan area could be met elsewhere. In the context of our case, whether development needs that cannot be met wholly within the Black Country should be met, could be met elsewhere. And that is a wider discussion than simply a two-handed discussion between the Black Country authorities and Shropshire Council. And I'll come back to that presently. And then paragraph 27 explains how you demonstrate discharge of the duty, and it tells you to do so through statements of common ground. And that's what happened in this case. The statement of common ground is with ABCA, but importantly, ABCA executed that statement of common ground by getting it signed by the 4 leaders of the constituent authorities. Now, Mr. Reid next places great store on the paragraph 11 of the framework, the presumption in favour of sustainable development. And it's important that that is read in context. It's paragraph 11b. Strategic policies should, as a minimum, provide for objectively assessed needs for housing. Well, that's a reference firstly to Shropshire Council's objectively assessed needs. And then it adds, as well as any needs that cannot be met within neighbouring areas. And that obviously includes the Black Country. But nowhere in Mr. Reid's opinion, second opinion, does he direct your attention to footnote 6. And footnote 6 says, as you will remind yourselves, as established through statements of common ground, see paragraph 27. So it's the unmet needs with neighbouring areas as identified in statements of common ground. That's the advice in relation to the legal duty. It does not require all unmet need from the Black Country that is not in the statement of common ground to be met, or even to be considered to be met. You know that other unmet need, i.e. other than that which has been agreed with Shropshire Council by ABCA, is being met under other arrangements. You know that the Black Country have existing statements of common ground with other authorities, which at present approximately accounts for about half of the estimate of unmet need. It's not precisely half, but a reasonable rule of thumb. In other words, at the time the Shropshire Plan was submitted, that was the state of play in respect of the emerging local plan to cover the Black Country. And as you know, because you saw and had were reminded of in its letter of July 2020, Shropshire Council said, in terms, we understand that further strategic, sub-regional or even regional studies are ongoing and not yet complete. And those, such as a strategic Greenbelt review and other such studies, those are important because when it comes to cooperation to determine where the remaining unmet need in the sub-region, in the Black Country, should be met within the sub-region, those sorts of strategic level studies are important. So that, for example, is it a strategically better fit for further unmet need to be met predominantly in one part of the sub-region? By way purely of example, and this is not a suggestion from Shropshire Council based on the evidence, but you will know that within the sub-region is Telford, a new town that was brought into existence to meet need from the Black Country. So one option in the future will be, should Telford expand to continue its historic role of meeting need from the Black Country? You know that there's a statement of common ground with South Staffordshire, indicating 4,000 houses. Odd. One question would be, is that an appropriate level? You know that Shropshire Council has not closed the door to further allocations if the evidence base suggests that it would be appropriate to have further unmet need from the Black Country met in Shropshire Council. And we're not discussing individual emission sites, as you've quite rightly said, but you have seen in the evidence that, as an example, Junction 3 has been mentioned. Now, talking of Junction 3, we're not considering emission sites, but I'm assuming that even if Junction 3 had been allocated, my friend Mr. Reid would still be submitting that the duty to cooperate had not been discharged, because there would still be further unmet need from the Black Country, even if 2,500 houses odd had been allocated at Junction 3. I mean, I say that slightly tongue-in-cheek, because we all know in reality that the objection from Bradford Estates is all about Junction 3. But conceptually, that's the logical conclusion of Mr. Reid's submission. He says, in terms, we should be looking to meet all of the residual unmet need in Shropshire before we can pass the legal duty to cooperate. Now, so far as practice guidance is concerned, again, there's no difference that it's the plan-making section of the practice guidance to which we look. And paragraph 11 is mentioned, subparagraph F. The agreement here, it is a two-part agreement. There is the initial agreement, and there is an agreed future process, in effect. Paragraph 12 is relevant, but again, redistribution within the wider area a two-part approach, the initial agreement and the agreed future process. And within that context, it's important to remember that Shropshire Council is responding to unmet needs in the Black Country and unmet need in an emerging Black Country local plan. Shropshire Council is not driving the process in the Black Country. Shropshire Council is some years ahead, 2 years ahead. It was anticipated at the submission stage of the Shropshire local plan. We're further ahead now the brakes have been put on plan making in the Black Country. It cannot be right, in effect, to suggest that Shropshire Council should pause its plan making until the Black Country had sorted out its unmet need. If we'd done that, we'd be even in a greater pickle now that the joint plan making arrangements in the Black Country have dissolved, and there will be even further delay on plan making in the Black Country. Paragraph 22 of the practice guidance is referred to, and that tells authorities that there's no requirement to reach an agreement, but it also tells strategic plan making authorities what they should do in the absence of agreement. Well, here, agreement has been reached. And there has been effective joint working. And then paragraph 31, which is relied on by Mr. Reid, that's guidance that tells local authorities that if they have not satisfied the duty, then they will be expected to withdraw the submitted plan. And in that context, Mr. Reid goes on to discuss examples. First of all, Central Bedfordshire. There, the inspector's complaints was that there had not been effective cooperation, whereas we say here there has been. In St Albans, that was a case where there was no agreement, whereas here there is an agreement. In Chiltern and South Buckinghamshire, again, there was disagreement. Here, there is no disagreement. The sub-regional evidence base being led by the Black Country authorities is not yet complete, but there is an agreement to look at taking a further element of unmet need if the sub-regional SEA or SA indicates that that's appropriate. And then returning to the paragraphs in the NPPF relied on by Mr. Reid, and in particular, he goes to paragraph 35A and 35C of the NPPF. But they are soundness issues. Those are paragraphs that tell us what soundness means. Then paragraph 61, the language of paragraph 61 echoes any needs that cannot be met within the neighbouring areas language from paragraph 11B, and we say that plainly must be read having regard to footnote 6, and the same applies to paragraph 66. So 3 points in conclusion. Firstly, we say it's categorically not the case, as submitted by Mr. Reid, that Shropshire Council should have to demonstrate that it cannot meet all of the unmet need from the Black Country. Secondly, there's a simple common sense check. Shropshire's a rural county with a population of about 350,000. And a 30,800 odd housing requirement and 300 hectares for employment development requirement. We're cooperating with 4 metropolitan districts with a population of 1.2 million and unmet needs of 28,000 odd. In other words, we're dealing with an unmet need in the Black Country of about the same order of magnitude of Shropshire Council's requirement. It is going to take more than one local authority neighbour to meet the unmet need from the Black Country. It is not a two-way conversation between Shropshire Council and the Black Country authorities. And thirdly, redistributing that unmet need from the Black Country is obviously a complex matter. It involves many neighbouring planning authorities who have different spatial and functional relationships with the Black Country. It's being led by the Black Country authorities quite properly, and it's not being led by Shropshire Council, that process. We assume that the emerging Black Country local plans, plural, evidence base, will look at, firstly, what elements of their need they can accommodate in the light of national planning policy, and where any unmet need should be met to maximise the achievement of sustainable development. That will inevitably involve a consideration of the competing merits or demerits of, say, Telford and Shropshire. Shropshire Council's agreed to an initial contribution, and for reasons which we explained to you last sessions, that contribution is based on its current functional relationship, i.e. migration and commuting patterns. We've agreed to ongoing cooperation and the potential for a further contribution should the emerging evidence base demand it. And that work, that ongoing work, will have to be done despite the collapse of joint plan making in the Black Country. And I finish by reminding you of something which is perhaps obvious. This is an examination of the Shropshire Council plan. It's not an examination of the Black Country authorities, plural, local plans, plural. Now, Mr. West is going to make some reply on the evidence trail issues, but that's all I have to say.
Thank you. I just one point that might be worth addressing, I think, in your response, Mr. West, is if you might be already planning on doing this, but something that Mr. Reid spoke about was, I think he was talking about the essay effectively, that the essay didn't address meeting all the unmet needs. So it didn't address what quantum of that unmet need, 28,000, could be met. And similarly with the Greenbelt review, that didn't address that. So can you just cover that when you're speaking, please?
Yeah, thank you, Inspector Crosby. Yeah, I think this was a topic which we did touch upon in July as well, but I'm happy to come back to it. And I recognise that Mr. Reid has raised it again. Effectively, our response to that is that because of the approach that we had proposed to deliver the unmet need, i.e. it was within our emerging housing requirements, that housing requirement had been tested through SA. So we undertook at the early part of our plan preparation process through the issues and options part of that process, a number of options around levels of growth around housing and indeed employment. So those strategic options were SA'd as part of that process because the contribution that we were proposing to accept from ABCA would be part of that. It is effectively, that is the essay of those reasonable options is also the essay of that unmet need kind of element of that. And in effect, that was the one reasonable option we factored into that process. So that's the answer on that point.
I think what Mr. Reid was saying, that you should have tested higher amounts based on the fact that there's an unmet need of 28,000. So it'd just be useful to hear what your thoughts are on that.
Yes, ma'am. I'll answer that. Because of the existing functional relationship, because of the lack of a sub-regional SEA, it was not a reasonable option for Shropshire Council, in effect, to preempt that work and to decide now whether it should take some more before there was an evidence base to say, for example, what was the impact of taking more in Telford or in South Staffordshire or in any, or indeed in any of the Black Country Authorities areas. The evidence base just wasn't there for Shropshire Council in isolation to make that sort of decision.
Thank you. I think just to elaborate on that, and I think it might be helpful for you to hear in this context, might be reassuring, hopefully, is that this whole discussion around an initial contribution, which I know Mr. Reid referred to, first of all, it's recognised within the Statements of Common Ground with ABCA 8.12, paragraph 8, it is recognised that the current evidence base to support the draft, the Black Country local plan would indicate a continuing need for ABCA to further increase the level of cross-boundary support and accommodating housing and employment needs from all of its neighbouring and adjoining council areas. So when Mr. Reid says that it's a sort of an add-on later, that we had assumed that this was a part of an on-running conversation, I would push back on that one and say, actually, no, but actually within the Statements of Common Ground, we've agreed with ABCA that was quite a central plank of that. In terms of that ongoing work that the region is based upon, and I've mentioned this before, it is a regional issue. This is one thing we just keep on coming back to. It is not a conversation with ABCA and Shropshire. It is a conversation with ABCA and the whole of the housing market area, the Greater Birmingham housing market area. Shropshire Council is not within that housing market area, it sits outside that. We attend the meetings because of our functional relationship, and we will continue to engage with the housing market area and the ABCA area in that continuing relationship. And if it's to give you some reassurance, the work of that group, which Mr. Reid refers to as those minutes which were included within the bundle of information from that officer group, the work of that group has, over the course of the last 6 months or so, led on to a wider West Midlands approach to this issue of unmet need. It has been fully recognised that a more strategic approach to the distribution of this need is required, and the fact that all the authorities within that area need to be part of that conversation. So that Statements of Common Ground we have agreed that Statements of Common Ground. Shropshire Council has, because we know that ongoing conversation is important. So hence why I push back on this point from Mr. Reid, who seems to I suppose place a question mark on this initial contribution. We very much see that conversation as on running. So that's our response on that one. I just wanted to raise just a couple of points as well, just for Mr. Reid. I just wanted to highlight some of the bundle that we put to the examination, particularly around ABCA, particularly around those conversations with the region I've just alluded to. Then there's no Machiavellian plot here about redacting notes. We just felt as though it was the easiest way to present information rather than having those minutes agreed by every single council. The more pertinent point was the conversations with us and ABCA, which was the duty conversation. So that is why those minutes are redacted. There's no wider plot here to try and hide behind information. I would point to the fact that the conversations we've had, and particularly the letters, particularly the formal letters which have gone to ABCA and from ABCA to us, clearly indicate the narrative around the conversations that we have had, and do show that we have considered this issue within the context of our emerging local plan. And I'll point to the letter, which again, dated the 7th of July 2020, which is the same letter which Mr. Reid referred to. So it's page 96 of GC 15A, Appendix A. Thank you, Appendix A. And in that, you will see top of page 97, a conversation. So it's a letter from myself through to kind of Ian, who's on the call, around around our emerging local plan, what it's there to do, the focus of the strategy, the fact how we are setting out our settlement hierarchy within that, the emergence of two significant options, brownfield options, and taking that into account on the basis of the constructed conversations as well as the emerging plan, we are offering the 1,500 dwellings as a proposal. That to me clearly shows that with those conversations show that the effectiveness of our local plan has been maximised, both in terms of the offer we have provided and the offer which has been accepted and agreed upon. So I'll pause there. It was just a sort of a point really to say that in our view, your question in terms of the master's question is around maximised effectiveness, and we do feel as though this does show that our local plan has maximised its effectiveness through these cooperations. It's one part of the local plan process. It's an important part, and we feel as though that process has been achieved. So I'll pause there.
Thank you. That's really helpful, Mr. West, Mr. Richards. I'll turn next to Mr. Kells from CPRE.
Good morning.
Morning.
I'm going to deal with a couple of issues, and I'm going to try not to repeat what Shifnal Town Council said, because they've covered some of the matters that I wanted to raise with you. I think the first point, just by way of the background to this, is in terms of the situation when the Statement of Common Ground was agreed to and the matter that we dealt with under MAT 2, the duty to cooperate had been, as far as we were concerned, in terms of the legal compliance, agreed with, fulfilled. We put out in our statement on matter 2 where we disagreed in terms of some of the soundness issues, but in terms of the process that Shropshire Council had undertaken, we didn't have any issues. The further bundle has provided a large amount of the detail of how it's worked through, which again seems quite appropriate to us. But I would just draw to one attention, and it's in our statement, in regard to the decision to withdraw the Junction 3 site. and it's referenced, and we refer to page 178 in that bundle. We are content that that was a correct decision. It was a decision that was made not to do with duty to cooperate. I think it's important to separate the two. It was made on the basis of Greenbelt policy, exceptional circumstances. It was made based on the evidence that was received from both from Bradford Estates and others, and from objectors. And I know because I wrote one of the reports that was involved in that, which gave detailed evidence as to that. I don't want to go into detail of that, and I'm sure you don't, but the point I'm making is that that was a quite correct way. And what it demonstrates, which I think is important to understand, is that when a council might consider duty to cooperate and consider housing and other things, it then has to review how that fits with its Greenbelt policy. And there are things that will override what it can and should offer to a council. So we're content that that was an appropriate reaction to consider sites and other sites as well, and then to come to a view. Obviously, we don't agree with everything they've said. So that's the first point. The second point is the assertion that the statement of common ground with ABCA is up to date and should still be relied on. And that is clearly not the case in our view. It is absolutely no longer relevant to rely on that statement of common ground. The first and most obvious reason is that the statement of common ground is now considerably out of date. It was made in 2021. There is considerably more evidence that has come forward, and I would just refer you in the council's response to this today, paragraph 1.11. They say what they've said verbally. The importance that it had been signed off by each of the 4 Black Country authorities. They go on from that to justify the figure of 28,239 at para 311. But if one goes to examination 41, statement of common ground at 8.4, the statement of common ground is quite clear. The evidence base which supports these forecasts and thus the level of unmet need is included within the Black Country Urban Capacity Study and the Strategic Housing Land Availability Assessment, both of which have been published on the Black Country website. In other words, when that was agreed to, it was on the basis of that evidence, not on the basis of the evidence that is currently available to the Black Country. And it was signed off by the leaders of those 4 Black Country authorities on the basis of that evidence. It is quite clear that the leaders of the 4 Black Country authorities do not now take the same view. Clearly Dudley doesn't, because that was precisely the reason that Dudley decided to withdraw from the Black Country plan, that they considered that the evidence, particularly in relation to the housing need and to the need to remove a greenbelt within their borough, was not justified. So clearly their view of that had changed by the time they made that decision to withdraw from the Black Country plan. So quite clearly that is not, that was the case that they agreed to it. Then it is not clearly the case that that can then be relied on as signed off by them now. And the second thing, and I won't go into the evidence in detail because you have it, we have significant new evidence. We have the census, which is set out. We have the Chilmark report, and the Chilmark report is quite clear that there is additional brownfield land available across the whole of the Black Country. So that is, we clearly have that evidence in place. That is the evidence that is current and is up to date, and therefore is evidence that should be considered had ABCA gone forward. But the Black Country plan has not gone forward. It is now being taken forward by the local plans. I referred to you in my statement to Walsall's local development framework. That is, I think, at the moment, the most detailed of the local development frameworks. They are quite clear that they are not simply continuing the Black Country Plan. They've made quite clear that the Chilmark report will be one of the elements that they will be looking for additional sites. They had a cabinet meeting. I was at that cabinet meeting. It was quite clear from the councillors and the comments that they made that they do not consider this to be a continuation of the Black Country Plan, but a local plan, and they intend to maximise their brownfield land. And also, by the time it comes forward to a state where they will be looking in detail at their housing numbers, they may well be looking at a different situation, given that the MPPF, the ONS 2014 figures are, according to Mr. Gove, going to be reviewed subsequent to the 2024 when we get the 2021 figures. So there is a certain amount of uncertainty as to what their overall need will be, how they will approach that. But quite clearly, even if they were working on these figures, they have said in their report that they will be looking at the Chilmark, and I've set out the extent to which that could affect it. So for those reasons, it is quite clear that it is out of date. A couple of other points. Firstly, of course, the position that is in the consultation with regards to Greenbelt, which isn't actually, in a sense, new, because Greenbelt has always required exceptional circumstances, and housing numbers have never been the only exceptional circumstances. And secondly, in regard to the 35%. Now, the council said that these matters were in the consultation. Oh, sorry, Mr. Bradford Estate said that these matters were in the consultation. But of course, the 35%, the fact that that should not be exported is moves to the MPPF, but it is currently in the National Planning Policy Guidance, para 034 of the National Policy Guidance. Is quite clear that that 35% should not be exported to local authorities unless there is either a legal or national policy reason for doing so. So the last one, I just want to, and I'm going to refer very briefly to my previous Matter 2 statement. It may be worth just bringing that up. My previous Matter 2 statement, the appendix, which is to my matter, it's M210. And if I can just bring it up on my screen. If I can just draw your attention, my Matter 2 statement, which is Matter 210, and if I can take you to page 56, which is actually the appendix of it, but it's our response to the Black Country Plan. And I just want to draw, there is the table 7. Can I just check you're with me? Yeah. So table 7, of course, is now slightly out of date. It's from the urban capacity study. And it shows then that at that time the potential shortfall, and that potential shortfall obviously includes is not just the unmet need, because it includes some sites that have been identified within the Black Country in other areas. But I just want to draw your attention, because one of the points that's been made is that this is really just a continuation of the Black Country Plan as it was. And I want to draw your attention to that final column and to the shortfalls that are identified for the local authorities, which are the ones that will be assuming we were under the same situation, assuming they don't find additional land, that would be required to look at. And in the case of Dudley, there is virtually no shortfall, which is one of the reasons they pulled out of the plan. In terms of Walsall, there's a shortfall of some 8,700. In terms of Wolverhampton, there's a shortfall of 8,698. The majority, I think, I haven't actually checked my calculation, of that shortfall would relate to the 35% additional housing which they are required to find within their own area. The vast majority of the shortfall is from Sandwell. So the point I would make is that when one is considering how housing should be distributed, and when we're talking about local plans for the local areas, they may well take a very different view as to where and who should be involved in that consultation, as opposed to they did under the Black Country Plan. You might say that at a practical level, that's perhaps something that should have been considered before, and that's the point we were making then. But the idea that we're simply carrying on, and that when they bring forward their local plan, it will be as I think was I think the words that were put were it continues to be the best avenue for dealing with need, and statements are up to date. We do not agree with that. We think that we need to look at the plans as they will emerge forward. Now, I appreciate I may have strayed onto the issue of soundness. It's rather difficult when that has been the topic that's been raised by the council and is in their submissions. So you'll appreciate that that's why I've picked that point up. But as far as we are concerned, therefore, we're content that they acted in the proper way. We made objection at the time. We think now that housing should be withdrawn, and consequently, since they're providing additional housing above their actual need, that would have implications for the plan that you need to take into account. And of course, the position is particularly pertinent because of Greenbelt, and as we know, the additional statements by the government of what it is looking for in terms of the examination of plans and the weight it wants given to Greenbelt. Thank you.
Thank you, Mr. Kells. So I'll ask the council if you want to make any comment. I can see Mr. Cully's got his hand up as well from Wolverhampton Council. Mr. Cully might have some points he wants to make as well.
Yeah, if I may just correct before Ian on that one. Thank you, Inspector Crosby, and thank you for your comments there, Gerald. I personally recognise that the CPRE recognised or consider that we have met the legal duty, which is acknowledged there. We haven't got any significant comments to make because obviously Mr. Kell's comments relate significantly on the state of the evidence, which is continuing with the Black Country Plan. I'll always say is it's a point which has been made today already. It's a fairly obvious point, but it's worth remembering is obviously we're not examining the Black Country local plan, we're examining the Shropshire local plan, but it's a fairly obvious point. But I think Ian may have some useful comments to make about evidence based on that one. So I'll refer to Mr. Cully on that one. Thank you. Mr. Cully, do you want to come in?
Yes, thank you, Mom. Thank you, Eddie, for the intro. So yeah, I think a couple of points. I think first of all, then we'd agree with Mr. Kells in that yes, absolutely, there are elements of the statements of common ground which are no longer up to date as a matter of fact. But I think in terms of the kind of wider approach that's in the statements of common ground, that's very much remains relevant for this examination. So in terms of the evidence, then the evidence which supported the Black Country Plan is still published on the Black Country Plan website. Had the authorities no longer considered that was the case, then that evidence and that web page could have been taken down, but it wasn't, and it's still there. It still exists, and indeed the individual Black Country responses to those local plans that we'd talked about earlier, so South Staffordshire, Stafford, and Birmingham, continues to give weight to that evidence in terms of the existence of a very significant shortfall of both housing and employment land against identified needs. So the authorities continue to contend that there is a significant shortfall on the basis of the evidence that was prepared to support the Black Country Plan, and yes, that evidence will be updated as the individual local plans progress, but we're not aware of any evidence which has come to light subsequent to the BCP evidence being progressed, which in any way undermines that position. So Mr. Kells referred to the Chilmark report specifically, which we obviously we're live to and are familiar with the contents of that report. So yes, that report did identify areas that the authorities could investigate in terms of potentially additional sources of capacity, and we are doing that as part of the individual local plan work. What it didn't do was to fundamentally question the extent of urban land supply within the Black Country authorities. It didn't do that. It suggested some areas that we could consider, but it could have suggested that no, the Black Countries were miles away in terms of understanding how much capacity there is in the on brownfield supply, and it didn't do that. And I think that's an important point to make, because that was well within the scope of the Chilmark study. One final point around the extent to where the shortfall arises across the four authorities. Then again, Mr. Kells is quite right that the majority of the shortfall arises in Sandwell, but there are shortfalls in Wolverhampton and Walsall, which are of over 10,000 homes, which the Shropshire contribution sits well within the shortfall arising in those two authorities on their own. The majority of the Wolverhampton shortfall results from the uplift, the 35% uplift, but not all of it. So I think around 5,000 of the 8,000 Wolverhampton shortfall as a result of the uplift. Our interpretation of the guidance is that yes, in the first instance, that uplift should be met in the area in which arises, but the guidance doesn't say it must be accommodated within that area, and that's significant. So the City Council will continue to seek to accommodate as much of the needs arising within the city itself, but our responses to those consultations that we mentioned earlier indicate that simply isn't possible, and we cannot accommodate our needs in full within the administrative area of the city. So that's all I wanted to say really on those points. But as I said, the overall message is that we contend that the evidence that supported Black Country Plan remains relevant and should be regarded as robust in terms of a basis for the Black Country Authority's position on the local plan examination. Thank you.
Thank you. Mr. West, did you want to say anything else?
Am I on? Sorry. Yes, I am on. Sorry. Yes, thank you, Inspector Crosby. It was just a small point, but important point. I think just about around the statement of common ground with ADCA is obviously at the point of submission. We felt as though that was up to date, which is obviously an important point here. As we've set out in our matters response, we do believe that the conclusions of that remain valid and up to date. There are clearly some factual elements of that which are no longer up to date. We can amend that if needed, but we don't think, our opinion is not crucial for your determination at this point in time. If you consider that's not the case and you do want us to update that, we can do. But that is all I wanted to say at that point. Thank you.
Thank you. It's 12 now. We said we'd take a break at around 12:30 for lunch. It probably is a good point now, rather than move on to the next speaker, to break for lunch. So if we break now and come back at 1:30, and we'll continue the discussion on from there. Okay, so just a reminder, if you turn your cameras and your mics off, but stay logged in, please. Okay, thank you. Okay, well, welcome back, everyone. It's just coming up to 1:30, so we'll resume. So I think next on the list was Mr. Carter. Mr. Carter, do you want to speak?
Thank you, Ma'am. I'm David Carter from Tyler Parks, representing the collective requirements of the NHS in Shropshire. My comments are brief and they relate only to question 10. Is it now?
It was seemed easier today, the nature of the hearing, that we just deal with everything.
Okay. As I said, they're only brief, but potential modifications to the plan were discussed last summer, and our representation stressed that the duty to cooperate is about more than the level of cross-boundary housing and employment requirements, and that health infrastructure provision is also a very significant consideration. Now, I'm assuming that the discussions last year are sort of already banked and there's no need to repeat what was said then. But just so everybody's aware, our concern is about securing funding arising from growth to support the provision of commensurate health infrastructure improvements. Now, in relation to this, I spoke to Eddie West at the council late last year regarding the proposed arrangements for the network to support the strategic infrastructure and investment plan. And I think it's fair to say the suggestion at that meeting was that those arrangements were imminent. So I thought it might be helpful if the council could update the examination of the progress on the establishment of those arrangements at any timescales from now on. Thank you.
Thank you, Mr. Carter. Mr. West, are you able to do that? We might have sprung that on you a little bit unexpectedly, but
always expect the unexpected. I've been told. No, thank you, Inspector Crosby. Yeah, I can update you on that. Yes, Mr. Carter is correct. It was mentioned at the July hearing sessions. We over the last few years, and this is just going back a bit really on this one, we have undertaken conversation with a range of infrastructure providers called the Strategic Infrastructure Forum. We are in the process of re-energising that process at the moment into a forum called the Strategic Infrastructure Network. It's a subtle change, but an important one. Letters have gone out, I believe. I think they went out, I think, before Christmas to a range of infrastructure providers, including colleagues from the NHS, because obviously they've gone through some changes as well in their organisation as well, particularly about who to deal with. And so we have sent letters out to that, and the proposal is to have a launch event in the spring this year for all infrastructure providers to attend. And as Mr. Carter has set out, one of the key purposes of that is to understand, and for the council to have those conversations with those infrastructure providers to understand that what their capital investment programme looks like, to marry that up with our growth aspirations, and to have a grown-up conversation around funding arrangements, including but not limited to the community infrastructure levy, which obviously this council is part of, and we do have a SIL regime at the council. So it's part of the understanding about where best for us to focus that SIL, and that's directly linked to the delivery and one of the policies in the draft local plan, which is DP25, I believe, which we did talk about in the July hearing sessions. It's not a strategic policy, so we'll probably talk about it again in future sessions if we get to that point. But yes, there were main modifications proposed to that to clarify how we feel as though that community infrastructure levy and wider developer contributions should be used. So the short answer, I've gone around the houses a bit. The short answer is in process. Letters are out. Launch event in the spring. So hopefully Mr. Carter is reassured on that point, and yourself reassured on that point.
Thank you. Yes, as you say, if we find that the council's met the legal duty, then we'll proceed to more hearings in time. And by the time we get to discussing DP 25, it's likely that there'll be some more news, hopefully, that that can, possibly become a main mod or something in the plan too.
I agree with that. Yes.
Yeah. Okay. Thank you. That's helpful. Next on the list, I've got Mr. Reid. Is that a legacy hand, or are you wanting to come back in on a point?
It's not a legacy hand. There were just a couple of points I wanted to come back on with regard to what Mr. Richards had to say in terms of a matter of approach for you. I'm in your hands as to when to do it. I'm very happy to do it after Mr. Maxwell. I can see Mr. Pollard are also now flagging up that they want to speak.
Yeah, I mean, we've got plenty of time to deal with everybody, so we'll deal with it now and then carry on down the list.
Yes, thank you very much, madam. In that case, can I deal with 3 points? The first of which is the application of paragraph 11. If you recall, it's the point regarding footnote 6. I thought I dealt with this at the previous hearing, but since it's been raised again, I thought it was important that you had our position on this. There's a reference in footnote 6 to the needs that can't be met within neighbouring areas as established through statements of common ground. And you remember the point that Mr. Richards said, well, you need to look at the statement of common ground in order to identify what those particular needs are. And my point that I made last year was that the statements of common ground are only so useful as they actually meet the relevant test or deal with the relevant tests, and they just don't. That was my ostensible point. But there's another point, which is that if that is thought to be right, namely that, and this is Mr. Richards' point, look, you look to the needs that are identified in the statement of common ground and nothing more. And of course, he had in mind the requirement, that's to say what the council was offering by way of 1,500 units or 32 hectares. But that's not what the NPPF is talking about. It's talking about the needs that you then go through the process of assessing under the caveats at sub-Roman 1 when you're looking as to whether there's a strong reason for not providing for them. And so you have to look at what the needs are within the statement of common ground that have been identified. And of course, if you look at the statement of common ground of ABCA, I'll give you, madam, the references because they're quite plain. The first is a very simple headline point dealing with housing, firstly, at 8.2, where it said that the total level of unmet need is 28,000. That's say in the Black Country area. And then same in 8.2, employment land, 210 hectares. So that's the need that even on the face of it has been identified. But if we're being a bit more generous to the authority, at 7.11, they then quote the ABCA response in apparently favourable terms. And you'll see there on page 9, the first bullet, you'll see there identified the netting off of the 28,000 against the various contributions that other authorities have made, which gets to the sort of level that Mr. Richards said is around about the half of the 28,000. But on any case, the statement of common ground sets out what the need is, and it's the 14,000. So actually, Mr. Richards' point makes our case. It's exactly what the statement of common ground and indeed the discussions needed to focus upon, namely the meeting of that level of need. So that's my first point. The second point concerns the argument that we, let's say Bradford, are saying that this authority needs to meet all of the available needs or all of the identifiable needs that are left over of the 14,000 or thereabouts. That's not our case at all. Our case is that there needs to be an assessment of the amount that can be provided of that total amount within Shropshire from the proper basis, which is are there strong reasons for restricting levels to a particular scale? And that requires assessment from the overarching 14,000, if you like, but from that overarching 14,000 and looking at the relative position or the relative justifications for delivering more than the 1,500 that's been offered. So between 1,500 and the 14,000, there's just no testing. And there's no testing either under the SA work and certainly no discussion with the authority, with ABCA, around that issue, just none. So that's my second point. And my third point is this argument that, well, it is actually all part of a sub-regional issue and it all needs to be joined up. And that ties in with this was an initial offer of 1,500 units. The first point is that in relation to dealing with it on a sub-regional basis, in order to inform properly the decisions within this council, they needed to, though I'm repeating myself, they needed to assess how much of that total amount they could appropriately provide for. And in discussion with the authorities, seek to, in discussion with the authorities, that's to say ABCA, come to a conclusion as to how much of that should be delivered, and that just wasn't undertaken. So there's no headroom above the 1,500 that's ever been looked at and discussed, and so that then, of course, would have provided some basis upon which further sub-regional conclusions could be reached in the future, but it was never done, and that's the essential failing of the approach that the council has adopted. And the second point arising from that is that, of course, the guidance is that you shouldn't be deferring the delivery of housing that is needed. If there is a need, you should be seeking to provide for it now. And as I say, you don't need to wait for a sub-regional division of those various elements in circumstances where you've actually undertaken the process of saying how much can we actually provide. But they just don't know the answer to that because they've never discussed it with ABCA and they've never tested it. And you'll remember Mr. West's answer to you, your first question to Mr. West was, well, what do you say about the testing above the baseline element that the council is seeking to provide for? And his answers are roughly translated, we didn't. And it's absolutely right that they didn't look beyond that in order to test the implications so that they could discuss the matter. And that's really comes back to the failing that I've identified earlier on. So those are the three short points I'd make.
Thank you, Mr. Reid.
Thank you.
Does the council want to come back on any else?
Yes, please. Just on the third of those points, Madam, if we can, please. We've explained to you that the 1,500 plus 30 is based on the existing functional relationship. Therefore, we think there is a sound basis for that initial offer. But secondly, what more ought to be met in Shropshire is not a decision that can only be met by considering the position of Shropshire. That is a position, that is a decision that needs to follow a sub-regional evidence base. That evidence base is quite properly being put together and is in the hands of the Black Country authorities. It cannot be sensible or required that, in effect, in order to bring forward its plan, Shropshire Council has to put in place that sub-regional evidence base. And therefore, we have agreed with the Black Country authorities the initial contribution and a promise to cooperate hereafter once the sub-regional evidence base is clear and once the basis for apportionment is clear and evidenced. And it is not sustainable to do anything else. And we don't think the plan making system requires it. But that's our answer to that.
Thank you, Mr. Richards. I'll take Mr. Maxfield next.
Thank you, Mr. Crosby. In fact, what I have to say follows neatly on from that last point. So I want to focus entirely on the area of disagreement between Shropshire Council and the Black Country authorities. In reply to Mr. Reid, Mr. Richards said that there was agreement between the two, or the Black Country authorities and Shropshire Council, but of course there's only partial agreement because what they're not agreed on is the mechanism for how Shropshire reacts to the sub-regional evidence base developing and coming forward as the Black Country authorities progress their plans. And really, my point is a very simple one. The complexity, and there has been a lot said about the complexity of the dealing with the housing market area, the Birmingham and Black Country housing market area. The needs spill out over several local authorities, and unless all of the local authorities in a perfect world are aligned in their local plan making, there will always be some evidence which is required for understanding either what the needs are or the ability of each individual authority to meet that need. And the area of disagreement between Shropshire Council and the Black Country authorities is what Shropshire does when that evidence comes forward. Now, our hearing statements suggest that this is the area of the duty to cooperate, where there has been, well, there should be more robust evidence. And as paragraph 22 of the planning practice guidance says, that where there's where agreement hasn't been met, an authority will need to submit comprehensive and robust evidence of the efforts it has made to cooperate and any outcomes achieved. So what the Arabia Estates, my client, says is that the duty to cooperate has not provided sufficient evidence of how Shropshire can react to that, the evidence base developing. And you'll see from our hearing statements that we propose a solution to that. I'm drifting into soundness matters, but that is because it is due to a failure of the duty to cooperate to get into the detail of what Shropshire needs to do once the Black Country authorities have developed their plans further. That is lacking. So that's our point.
Okay, thank you, Mr. Maxfield. Do the council want to come back on that point? It was something we discussed quite a lot at the first lot of stage one hearing sessions, wasn't it, about whether there should be a trigger or whether you rely on the natural review process set out in the NPPF.
Yeah, Madam, that's entirely right, and it's there in Mr. Maxfield's latest hearing statement again to remind us. But that's a soundness issue, not a pass-fail duty to cooperate issue.
Just if I may also, Ma'am, Mr. Maxfield would indicate that we haven't set out clearly our view on the early review trigger system mechanism, which is what he's referring to. The statement of common ground does set that out as an area where we don't agree with the ADCO authorities on. It is the one area, so he's correct. It is not a full area of agreement, but of course the duty to cooperate is not a duty to agree. We all know that. So we set that out quite clearly, and our rationale, as is set out in the Statements of Common Ground, under Section 9 of the Statements of Common Ground, is that we believe our local plan review cycles align with the ADCO area quite closely. In any case, I would say that one of the outcomes of the cessation of the joint plan recently and the preparation of the 4 separate plans is that, in fact, in my view, is that continues to be the case and is more the case than it was in July. We are probably 2 years ahead, I would say, possibly more on that one. So our argument is the same, and that's our response. But you've obviously heard about that in our July sessions as well.
Thank you. Mr. Cully, did you want to say something on that point? I can see you've got your hand up.
Well, yeah, very, very quickly, just to confirm really that the Black Country Council's position is that we don't consider the early review trigger to be a legal duty to cooperate issue. It's very much a soundness issue. So just really to confirm that's the case. Thank you.
Thank you. Okay, so next got Mr. Pollard.
Thank you, Ma'am. I suspect this will be brief because Mr. Maxfield has already identified one of the points.
Still in your thunder.
Yeah, he has indeed. What can I say? But I'll just signpost very quickly because I didn't want to rudely just take my hand down. Clearly, in our statement, we paragraph 1.10, we affirm the council's submissions, the aforementioned bundle. Clearly, in our view, does show an ongoing dialogue. So that's acknowledged. Been listening to the conversations today, and I know a number of participants have raised the point around uncertainty and evidence and need. But from my perspective, I haven't heard anything that fundamentally gets to the heart, certainly of what the issues that Shropshire could fairly be taken into account in terms of the scale of unmet need, and it clearly is a significant sustained need. And my point was going to be that that goes to where that's been raised, that goes to the point around the early review trigger. And I mean, I'm not going to go over the old ground again that was been made there, and I would agree that it probably goes to the point of soundness and for discussion another day. But there were some clear references today by the council to this issue of unmet need not being a closed door or the end of the story, and I think that's important. And I know the council's response back and the potential aligning of phasing of plans, etc., but where quite a lot of reliance has been put on this release of relevant sub-regional evidence, I think that's perhaps something to take into account in terms of that trigger, rather than simply waiting for the local development scheme's progression. I think the point there's a demarcation there between evidence and the plan itself being the relevant trigger. Thank you.
Thank you, Mr. Pollard. Does the council want to come back on any of those points? I think they're quite similar to what have been made previously.
Yeah, I don't think we've got anything further to say. I think, as I said, it was a similar kind of point with a similar kind of response from us on this one. In that, just to reiterate that we feel as though there's an appropriate a review mechanism in place naturally in any case. There may very well be a number of reasons why an early review is needed. This and you know we will wait to hear your, I suppose, your views on that. But you know our view is that on this issue an early review is not necessary. But I'll leave that in your hands.
Thank you, Mr. West. Has nobody else got their hands up? So I assume nobody else wants to speak. Do the council want to make any final comments? I haven't got any more questions. I don't know whether I don't think Ms. Dillon or Mr. Palmer have got any questions. I've not indicated, so so just check. Do the council want to make any sort of final comments?
We don't have any final things to say. I think we've set out the case very clearly today. The case around the information that we've provided around this issue is in a number of documents. We've set that out quite clearly in our responses, most recently to your matters questions, which you have before you. We don't have anything else to say at this point. I'm just checking around with my colleagues. They're all of the same opinion, which is good. So no, in short, we don't have anything more to say. So thank you.
Thank you. I'll just check with my colleagues. Is there anything else? Anybody? No.
No.
Okay. So yeah, I think we've got everything we need. It's been a really helpful session actually, just to clarify things, and it's great now we can do these virtual sessions without all having to trek across the country for a few hours. So it's been quite a good use of technology. Okay, so the next steps is we'll obviously consider what's been said today and write to the council. If we find that the council has met the legal duty, then the letter will be much longer, and we'll consider lots of matters that we heard at the first stage 1 hearings, as well as some of the matters we've heard today. So we'll set out our thoughts on lots of different things. Obviously, if we find that the council hasn't met the legal duty, the letter will be much shorter. I anticipate that the letter is going to take a week or two, because we're going to have to sort of get our heads together and think about it. And we do have an internal QA system for letters, and it's public knowledge that those sorts of letters as well have to be sent to DLUC for them to see. They don't have any input into the letter, but they require notification before we issue them of what we're actually saying. So that all takes a little while to do. So we'll obviously get on with the letter, and we'll keep Kerry and Ian informed as to progress on that and when the council are likely to receive it. But I'd like to think really within the next couple of weeks. Okay, so unless anybody's got anything else, then we'll close today's hearing. Okay. Did you want to?
Sorry, all I was going to say was thank you for your time, and thank you for everyone on the call. All it was to say that. So thank you very much, and we look forward to hearing from you in due course.
Okay, thank you. Thanks for your help today.
Thank you.
Bye.
Goodbye.
Bye.